Good evening. Welcome you all for the monthly labor law update, June 2021. Um, this update, we would be starting with the Code on Social Security Employees Compensation Draft Rules. It is like your Workmen's Compensation Act 1923, which is then retermed as Employees Compensation Act 1923. Um, in these rules, what has been significant is that there is an interest component. So if you fail to pay the compensation within 30 days, 12% simple interest will automatically start to be attracted, is being provided for. Apart from it, the rules more provide with regard to how the money is to be deposited, and if one authority to the other authority, and places where an application can be made for the compensation. So the person can file an application seeking compensation either where the accident took place, or where he resides, or wherever the registered office of the employer is located. So in all these three locations, a person can file an application. So these are the draft rules that have been circulated by the central government for asking comments, and thereafter this has to be formulated into the rules. There's a small amendment under the ESI pertaining to maternity benefit, which is more to do with the contribution period and the benefit period. You're all aware it's a 6 months contribution, and the following 6 months is called the benefit period. There was a slight lacuna there, and therefore to that they have amended it so that the maternity benefit for the entire 26 weeks can be received. But again, this is the draft rules, and should once notified, it will come into force. Um, the EPFO had come out with a notification for medical advance, especially for the COVID. So any employee or even a family member of an employee could make a application, and on the same day they will process and release 1 lakh of medical advance, and even a higher amount can be asked for, and that will also be processed in due course. And employee is required to submit bills for it within 45 days from date of discharge. Um, Another notification that came about was with regard to seeding of the Aadhaar. This is pursuant to the section that has been notified under the Code on Social Security. They have now deferred it to 1st September 2021. So by 1st September 2021, all employees' Aadhaar details would need to be filled in, failing which the monthly return ECR challan will not be able to be uploaded for those employees. Um, we have our reservations on this. If an employee doesn't furnish the Aadhaar, the employer cannot in any manner be punished for it. Maybe they could have stopped the employee from withdrawing or employee asking things in the event of uh, the employee not furnishing Aadhaar. But what has happened here is that they're now saying that the employer can't even make the contribution if Aadhaar is not seeded by 1st September 21. The ESI Corporation has also, for the COVID-19, has made certain additional benefits, sickness benefits, for them to be claimed for each. And even a deceased employee's spouse is entitled for medical insurance on a very nominal contribution of 120 per year. So this is another lot of COVID related, both ESA and PF this month. Similarly, um, in respect of where uh, uh, the member dies as well as the spouse of the member is not alive, then the children. Otherwise, normally what happens when the member dies, the spouse gets monthly pension, widow pension. But in this case, they are now extending it even to orphan children. This is not to do with COVID, but COVID has led to this to some extent. So that is how it has been programmed. The Tamil Nadu government has extended the various requirements for permissions of factories, which are to falling due between May and September. They have been extended for a period of 6 months from the various requirements. Under the POSH Act, uh, Maharashtra government has said that till now there was no appellate authority under the POSH Act. So the Labor Court or the Industrial Tribunal will be the appellate authority under the POSH Act, is what the notification of the Maharashtra government. We have from last month started a quiz section. So under the Occupational Safety Health Code, worker is entitled to annual leave with wages if he has worked for how many days in the previous year, is the question for this month's quiz. You have your options there. Please feel free to put your answers in the chat box, and we shall look into the answer at the last slide. A news article has come out yesterday wherein it has been said that the Apprenticeship Act is likely to be amended to give more flexibility, where the colleges can run apprenticeship programs. So it could be a part-time course of like 4 days in college and 3 days at work, or you can be able to bring in. So a lot of new things are likely to come up, is what is being said. And the 15% strength is also likely to be increased, uh, is what is the grapevine about it. This is more required now because under the IR code, the draft rules for standing order draft rules that have been model standing order that has been circulated does not provide for trainees. So only act apprenticeship is going to be the way forward, and therefore this amendment to the Apprenticeship Act becomes a necessity. We hope that the government does amend it. This month, we thought we would discuss a little bit about subsistence allowance. It's not something new. Many of you know what a subsistence allowance is, a payment that you do to an employee when you keep him under suspension. It's like the contract is kept under animated suspension. You don't want the employee to come to work for whatever reason it could be, and therefore you keep him under suspension, primarily when there is a misconduct done by him and you want to inquire about it. You keep employees under substance allowance. Where does this requirement arises from? The Standing Orders Act provides for it, or state legislations also have been there. Many, few state legislations we have tried to put in here to show that what are the uh, sorry, 1 minute. I'm just told that my voice is not audible. I hope it gets better now. Um, so the state amendments also provide for it. Uh, Similarly, they've brought in under the IR code as well. An amendment has been brought in respect of the same substance allowance of say 50 days and 50% for first 90 days and 75% thereafter. Uh, what happens to the state enactments vis-a-vis the IR code? Because the IR code is going to replace only the ID Act, Standing Orders Act, but your state enactments, they are not being repealed by the IR code. So will your state enactments prevail or will your IR code prevail would be a question to be looked into. It's more likely that the state enactments which are more beneficial will prevail over the IR code. That is the legal interpretation could come only to that. So that's one aspect of substance allowance. Um, Normal pay quantum of provided under different enactments. Normally it is 90 days, 50% and 75% thereafter. And after 180 days, it goes to the normal pay. Um, there are certain judgments, even under section 33(1) and 33(3), you would need to seek permission of the tribunal or the wherever your labor dispute is pending. In such cases also, you would need to continue to pay subsistence allowance. In some cases, subsistence allowance have been ordered by the labor court also. So even after dismissal, in some cases, if a dispute is raised, of course, they are rare of rarest cases that the labor courts have ordered for subsistence allowance as an interim relief. Similarly, the new IR code also enables or gives the power to labor courts to order for interim relief that could also again be in the manner of a subsistence allowance. Of course, subsistence allowance requires that the employer-employee relationship should be there, but it is only akin to that that the labor codes order. Under the ESI, you're liable to pay ESI on subsistence allowance. That's a Supreme Court judgment. Provident fund is concerned, normally Provident fund is not paid on subsistence allowance because though it is kind of wages that you pay, it is not considered as basic pay and PF is not paid on subsistence allowance. There are circumstances where you may need to regularize the subsistence allowance. Of course, you can never recover it from an employee. So recovery will never arise. But let us assume that two things could happen. You suspend an employee today, and then in inquiry it comes out that he is not guilty. What happens to his suspension period then? Because he would have got 50% or 75% of his salary alone, what happens to that? Two, there could be a scenario where he is found guilty and you don't dismiss him or terminate him, but you give him a lesser punishment and he comes back to work. In both these scenarios, the employee is entitled to 100% of his wages for the suspended period unless your regulations or your standing orders provides or enables you as an employer to pass an order saying the period of suspension is not being regularized. You should have that power to say that the period of suspension is not being regularized. So if such a power is not there, it will automatically get regularized. The employee will be entitled to full salary for the entire period of suspension. In two occasions, two conditions I've said, only in those two. But if you resort to dismissal or termination, the employee will not be entitled to anything more. But if you don't do that and you put him back into service, then he would be entitled to full wages. Is another case law that we had on this aspect. Under the OSH code, if you're a hazardous process industry, within 30 days, you would need to inform the chief inspector cum facilitator, failing which your license could be cancelled. Your nature and what is the kind of process that your industry is into should need to be informed to the authorities. Sorry. Under the OSH code, one more provision is a fine amount that is collected from an employer can be given to the employee who has suffered, who is a victim of if he suffered anything because of an accident or bodily injury, or to the legal heirs of the victim. Up to 50% can be, the fine amount can be given. We have discussed in the past on the definition of wages under the codes. The Code on Social Security provides for maternity benefit, and the definition of wages. See, as on date, if you look at Maternity Benefit Act, if an employee is, let's assume, getting 25,000 rupees as salary or wage for the month, during the maternity benefit period also, you will continue to pay the same as maternity benefit. In the Code on Wages, the definition of wages excludes, for instance, house rent and conveyance. So out of this 25,000 rupees that you have been paying all these years, if 5,000 was HRA and 2,000 was conveyance, you don't need to pay the same under the Code on Social Security as maternity benefit. Therefore, only 18,000 or so the employer is bound to pay or required to pay under the Code on Social Security. This provision of law has now been challenged before the Madras High Court by a Working Women Forum, stating that a benefit which is already there is sought to be taken away by the by the Code on Social Security. So this is an interesting development which we need to see, because if they amend this definition of wages, Will they amend it for purposes of gratuity or PF or other aspects also is something that we may need to watch. Um, a very uh, different case of where the employer filed a suit against a trade union because the trade union was giving or spreading incorrect information about them, and therefore they filed a civil suit. Relying on Section 18, the Madras High Court has said that the suit is not maintainable. Uh, Personally, I'm of the view that this judgment may need a relook, because what is barred under Section 18 of the Trade Union Act is pertains to dispute between employees and workmen, or anything to further trade dispute. But this is a case where the trade union was spreading incorrect information about the employer. I don't think Section 18 was meant for it. Therefore, I think this judgment may need to be reviewed at a later point of time. This is a case of non-payment of provident fund on time, levy of damages. Already, Supreme Court has held that a mens rea should be there to levy damages. The Madras High Court, in this case, once again reiterated the same and said that the company was in a stage of winding up, and therefore the question of payment of damages would not arise. The COVID times has posed us a lot of challenges, and one person in tweet had put in that why people don't want to go back to office, and the major reason seems to be very, very funny. I thought so. We thought we'll just put it, share with you the thoughts here about it. Such a large percentage of people don't want to go for a very great reason. These is your complaint issues for the next month is there. And lastly, going back to the question or the quiz, it's 180 days. Currently, under the Factories Act, it is 240 days. Under the new code, it is going to be reduced to 180 days. Thank you all for joining. We will connect again on 31st of July at 4 p.m. Please do join us then. Stay safe till then. Thank you very much.